I can certainly do that, Your Honor. If the court wishes to listen to the recording, I can certainly do that.
Which recording are you referring to? I haven't read the papers.
Okay, so
Sure.
What I have with me, Your Honor, is the recordings that are referenced.
Yes.
The recordings that are referenced in the complaint. However, in the interest of an expert, intended as exhibits to the pleading of excerpts from those interviews.
Yeah, and I've read the excerpts.
Okay, so while I certainly have the recording.
Yeah, I'm not sure we need to.
Give the court. Forgive me, I didn't quite sentence here. As the court indicated, what the credit union is seeking is this is a temporary hearing on the credit union's request for injunction. The position of the credit union is outlined in the papers which the court has currently taken the time to complete this one's hearing, is that the statements that were made by Mr. Alfuca during the interviews that are referenced in the pleading are definitive.
What specifically? I mean, because in your prayer for relief, you're talking about statements of the type made during these interviews. There's not really any specificity in your prayer for relief as to what you think is defamatory.
Well, certainly in the proposed order that was filed with the pleading, and I've since modified for purposes of today's hearing, if you would like to see it.
Sure, I'll take it.
May I approach?
You may.
It goes through, and as the court points out, going to the bottom of the first page, making any defamatory statements about or in any way related to Granite State Credit, his office's agent service, including by way of example. And so I go through and I delineate those items, those assertions that are in the credit union, that Mr. Fugo has made statements regarding that it believes to be defamatory. Because if I could try to cut to the chase, and I tried to outline this in the plea. From our vantage point, it appears that this, the assertions that were made in these interviews stem at least in part from the divorce proceeding, or at least they were fueled by the divorce proceeding, which I'm sure the court is aware of, along with a separate civil action that I know that the court is aware of. And so, given the facts as are outlined, that there's no dispute about the fact that the mortgage in question, this mortgage that secures payment of a home equity loan, was something that Ms. Del Fuco certainly acknowledged that she agreed to do. There's no dispute about that. And it also appears that there's no dispute about the fact that at the time that the mortgage was granted, the property was granted, and that the underlying loan obligation, the home equity loan, is the loan obligation of Ms. Del Fuco's ex-husband, Mr. James Gove. And based upon the record, it appears that there was an agreement, and I believe this was the subject of the lawsuit that Ms. Del Fuco brought in this court. She brought against Mr. Gove, realizing that we were going between the two of you. They called for after apparently this loan obligation was approved, that he would have to make some things. Apparently he stopped. And then once he stopped, then apparently these issues that she's asserted began. And she's asserted, starting with that, made assertions that the underlying loan obligation was the subject of the fraudulent act. That's what she's alleged, as it relates to Mr. Coe. And she started with the banking department. And she started with the banking department, as from what I can see, shortly after the time that supposedly Mr. Coe stopped making payments in April of 2013. The banking department issues its decision in the complaint in August of 2013, denying that there was a lack of information price was anything to it. She then brings the action in this court, obtains judgment, then files a second complaint, basically alleging the same thing. Copies of the complaints are appended to the pleading as exhibits B and D. And the response of the banking department to each of those complaints are at exhibit C. And on each step of the way, the banking department is clear as far as its review, based upon response to the credit, that there was nothing improper. It's not apparently.
When she claims in the paperwork, she says, I noticed he is saying we were married and living in Bow Street together. He says those two statements were false. Do you disagree with that?
Well, in terms of whether or not they were living together,
I mean, you may argue it's not material, but
I will, as a matter of fact, I don't think it is material, because I think that's actually referenced in.
but you're not arguing that it's false. You're not disagreeing. She's arguing that's a false representation made by Go. Do you
Well,
disagree?
I don't know.
Hold on. Do you disagree with that, sir?
Do I disagree that?
She says that's a false representation made, that they were living together and married at the time of the loan. I'm asking, do you disagree with her?
I don't know if that's true or not, to be honest, Your Honor, but I will represent to the court that I don't believe that's a material fact. So as I stand here, Your Honor, I don't know that for a fact. But the issue is as to whether or not, in as much as it's not a material fact, see what it could be, and I think it's, not to, for lack of a better phrase, not addressing the court's query. Exhibit C is the response of the banking department, which includes the letter from the credit union. And I believe in the third paragraph, it addresses what the credit union's position is to that query with this name. That is to say, the information provided by Mr. Phil did not indicate.
I'm sorry,
this as-
what exhibit here?
This is exhibit C.
Okay.
Exhibit C, which is the banking department's response to August
Yeah, I'm reading that.
2013. First paragraph of which has a copy of the response and is enclosed for your review. This is a letter which is from the credit union signed by, at the time, Ms. Johnson, who was AVP of Mortgage and Commercial. Third paragraph. I may read, as discussed in our phone conversation in July 9, 2013, there was a clerical error on the address of James on the mortgage. As this was not brought to our attention at the time of closing, we are not aware of the error. The information provided by Mr. Goey did not indicate it says its home address for mortgage purposes. The statement of the address is not a critical aspect of mortgage lending, and therefore the mortgage remains valid, notwithstanding this address. So that was addressed back in 2013. So to continue on, it appears that having brought the action against Mr. Goe and obtaining the judgment, which I believe was August of last year, there was yet another complaint, basically asserting the same thing, the same assertion, which was again responded to by the which included yet again another response from the credit union, which included copies of the mortgage in question, as well as two other documents that were signed with the South Dakota. Apparently, according to Ms. it appears that Ms. Lutherford didn't believe that that was sufficient. So assertions that are being made. The court has seen it from the excerpts. The substance of the assertion is that we credit union basically turned a blind eye to fraudulent activity. And that assertion has been made repeatedly at the time of the interviews that are referenced in the plea. Both the December 1 interview on the program Speak Up, that was hosted by Mr. Abar, and I believe December 14th was the date of the one that was conducted by Mr. Gill. Both of which broadcast. Now, we're not here having to do with those folks. We're here to deal with Ms. Dunn and the assertions that she's made. I also think it's important to point out that there was efforts to try to address these issues directly with Ms. Dunn. Over and above what was done with the bank.
You know, I'm looking through the interview. I think this is the one with Mr. Is it Avery? Abar, I'm sorry. What is it? What statements in this interview particularly point to as being bad? I mean, I understand you're objecting generally to defense suggestion that there was some sort of fraudulent activity here, but you're asking for prior restraint on speech, which you know, when looking at case laws, is a very difficult standard to meet. And one of the things you have to do is point to specific statements that are defamatory as opposed to asking for this in such general terms.
I certainly know that. The reason why
So what's the answer? What's the answer to the question? Which statements are you saying are defamatory in these two interviews?
you go to the exhibit,
Which interview is this?
this is the interview with State.
Okay.
Your Honor, if I may correct, it's not Mr. Abard, it is Senator Kevin Abard. Please give him the respect that he deserves.
Question out loud, this is clear fraud, yes, misrepresentation, attention. And you brought this to the attention of the FBI, Federal Prosecutor's Office, to grant state credit union to the bank. And to continue.
In the next page, you focus on the fact that the application suggests that she and Mr. Goder are still living in the same address.
Your Honor, I want to object to that because Mike Gill is here to testify on my behalf, and I feel that with him using Mike Gill as a reference, he's trying to put a black cloud over the case and what is really there. And I would like to move forward, if that's all that he has with my side of the case and prove all of the facts.
I'm going to let him finish his argument. I'm going to overrule the objection because this is one of the leading cases on prior restraints of speech in New Hampshire. It just happens to involve Mr. Gill's company, but there aren't that many cases on this topic.
Okay, thank you.
And so in that case, the New Hampshire Supreme Court, which it originated with the mortgage specialist seeking injunctive relief and obtaining injunctive relief, and the injunction concluded that the defendant was ordered not to repost or republish and make reference to certain defamatory postings, and also that's in paragraph 4 of the which I'm referencing from page 232 of the decision. In addition to paragraph 1,
Page 232.
160 and page 232. Unless you have the advantage.
I think I do have the
I'll be happy to hand it up.
That's
That's a copy.
Sure, I'll take it.
I'd like a copy too.
Absolutely. And I have.
You may.
Thank you.
If you can try to wrap this up.
Oh, sorry. This case goes through a litany of cases that sets forth types of cases that are decided by the U.S. Supreme Court having to do with restraints on speech. I think they all.
What page were you referring to?
Well, I was referring to page 232 as far as what the scope of the trial was. So the mortgage specialist obtained the injunction. which interestingly, import-export, as I understand it, was viewed as being, in effect, a media entity. As a matter of fact, on page 233, it says, although our cases discussing news gathering privilege involve traditional news media, such as newspapers, we object to Workers' contention that the news gathering privilege is inapplicable because employer is neither an established media entity or engaged in investigative reporting. Trial court was found that Info is, quote, a legitimate publisher of information and a member of the press. That clearly is not the situation here. And then the cases, if I could fast forward to the excerpt of the decision as relates to the injunction, which appears at page 240. That's entitled Secretary Republication of the Loan Shark and Brian Gadsby's posters. And the court goes through and it reviews case by case in terms of cases that involve seeking prior restraint. And they all deal with what I would summarize, what the court summarizes, as being constitutionally protected speech.
But by that, do you mean they all involve the media?
No, I think there's a true form. I think there's two.
Right. It's clear that the restriction against prior restraints applies beyond just the media, right?
I'm reporting the fact, well, certainly, an individual's entitled to his risk of rights. If that's the court's question, is sure, absolutely. But I'm talking about it from the standpoint of getting injunctive relief. This case clearly establishes the proposition which the court began the hearing with, is that the fact that there's a very high bar on injunctive relief. I acknowledge there's no debate. However, look at the cases respectively. The cases involve folks that are media outlets, and they involve those types of activity that fall in the category of constitutionally protected speech. Things that are of the public concern, but as a matter of fact, and if you were to go through each of the cases that are outlined here, they involve such things as the Pentagon Papers, which is obviously I'm sure the court is aware of. And there's a series of cases that involve publishers and news media, and they also involve activities that are purely public nature.
It's true, but the cases themselves involve the media. People, so I don't know. I think I need to see more case law.
Well, I think this case summarizes it in terms of the various decisions to get to the point where it concludes in the final paragraph of the decision. It's interesting. If I may read from the last page of the decision. On the second sentence, accordingly, we conclude that mortgage specialists' interests in protecting his privacy and reputation do not justify the extraordinary remedy of prior restraint. As the Supreme Court has recognized, there's no decision warrant to claim that the interest of an individual being free from public criticism of his business practices warrants the use of injunctive power of the court. And then it goes on to cite to Keefe. And the Keefe case, which is the Organization for a Better Austin versus Keefe, I also happen to have, if the court would like it. It's interesting that, again, this is a 1971 case involving media, involving actions by a real estate broker, which in that case, known as the Organization for a Better Austin, believed that this real estate broker was basically engaging in racial activities. It was, in effect, trying to have folks fear that.
Let me start to ask you one last question.
Yes, sir.
The case law that I've looked at, when it allows a prior restraint, typically it does so after a full evidentiary hearing and a final order that says these statements, specific statements, have been found to be defamatory. I haven't seen any prior restraints really come outside of that context. We're not there yet. Would you agree with that? I mean, this is a preliminary hearing. We haven't had an this isn't an evidentiary hearing, and we've made offers of proof here, essentially, right?
Well, let me also, that's true, absolutely. There's also, I think it's important to know that we're here because Ms. Del Duco apparently is not done doing what she has done so far as engaging in these interviews. Appended as an exhibit as well as an email to my office on January 8th, which is really, and I think this speaks to the reason why I believe that this this case falls outside the purview of the case law in terms of what we're talking about. This is an email of January 8th that indicates basically, the court can read it, but she's basically making demands to the credit union. And if she doesn't get what she wants, these are the things that she's going to do. And that, respectfully, I submit, Your Honor, does not, which is the reason why we're seeking the injunctive. And certainly the nature of the speech, again, is not constitutionally protected speech. And we're not looking to prevent her from being able to offer her opinion as to other matters. Obviously, we're just focused upon this issue that's been the subject of this particular one loan obligation. And she, I will acknowledge that in the course of doing so, she also made reference to some purported improprieties that relates to other mortgage obligations that she has incurred. But the fact of the matter is that we're seeking the injunctive relief because of the fact that she has indicated an intent to continue with this activity.
All right, let me hear from the defendant.
Thank you.
Good morning, Your Honor.
Good morning.
Can I please call Mr. Mike Gill? He is here, and I just have a couple of brief questions. Since he's already been brought up and brought into this, I'd like a couple of things cleared up.
Well, just tell me what you're going to ask him about.
I'm going to ask him about predatory lending, since he does own the mortgage specialist. That's been brought up in the interview, and I am going to also ask him on the corrections of the interviews, on what he said and what I said, that I did make corrections on these interviews. Never once have I done anything dishonest or misled the public.
Well, I've seen the correction that you made in
Right.
Mr. Gill's interview, so I don't, we have the transcript of that, so I don't need any testimony as to what's in
Okay,
in
because I mean,
the
they're
transcript of
really
it.
accusing me of putting them down, and I'm not.
Well, I think the suggestion here, I mean, the argument, their strongest argument they make is concerning the title question, where you argued several times in these papers that Mr. Go didn't have title to the property. And you know, before this court, last summer, I ordered him to issue the quitclaim deed, so certainly at the time of these relevant transactions, he had title to the property.
May I approach the court with other information?
Why don't you pass it to the bail?
So they're claiming that, he keeps going on the application, and that is what stemmed it. What actually stemmed it was two court cases that were from here. And one was the divorce case 618-2010 DM0064 with Judge Weaver and two other previous judges. That's what prompted the interviews. These interviews do not go just to say, this is what happened to me, don't ever go back to Granite State, they're a terrible bank, da-da-da-da. These interviews that I am doing points out corruption, it points out a lack of laws to protect consumers and mothers like myself, and it covers everything. It also covers court case 218-2014 CB01145. Your Honor, you're the one that hears that case. You just heard the case the other day.
Right.
In that one there, I never addressed anything about the applications and all of this because I was going after him for the amount due. Granite State is the one that's coming after me for my house. I have a copy of the application right here. Mr. Goad put my address on this application. Mr. Goad also wrote that he never filed bankruptcy, and he did. And it's documented in this court, in the side of 218-2010 DM0064, that he did file bankruptcy.
And the bank isn't really arguing those statements.
Well,
Word falls, they're
those are
arguing-
the statements that are coming up.
They're arguing they're not material.
Well, they are material, because the bottom line is mortgage fraud is investigated by the FBI. This is handed out to all the banks from the FBI, and it is right here. 18 USC-1341, fraud and swindling by mail, and then we have the other one here, 18 USC-1028, fraud-related activity in connection with identification documents. I mean, no, this is the big one for addresses, 18 USC 1342, fictitious name or address. That is bank fraud. Now, I hold here a copy, which you all should have too, December 11, 2015, from Celia Bushy, investigator, Consumer Protection, Antitrust Bureau. Okay, she goes on to write an email to the acting United States Attorney in Concord. The bottom line says, the most tribal criminal conduct found would be most applicable under the federal bank fraud statute. You have a copy of that. I am speaking with Senator Abard, who did the interview, and running elective Mike Gill, who is running for governor, Your Honor, to change the laws on the state of New Hampshire, so bank fraud and everything does not happen any longer. I am doing these interviews under the First Amendment of freedom of speech, the expression to write the petition, and the petition to government for redress of grievance. I'm also doing this under the right to information.
Ms. Doe, do you have an objection?
Yeah, yes, Your Honor.
What is it?
She's come in here, certainly this is the first we've seen of these documents.
That's a temporary.
Siri,
I understand that, but it seems like she's making a lot of assertions on her own, as if there were other people saying, I didn't see this temporary. But certainly we've got so-and-so saying this, so-and-so saying that, making reference to articles and things of that nature. I'm trying to stay focused on what this issue is.
Well, I am too, but those are letters that I'm receiving from New Hampshire State Departments, and this
I'm
is also
going to
from the
overrule
Department of
the motion, but
Justice.
if you can
I'm trying to
fairly
tie that.
quickly summarize.
I am, I'm trying. I also have something here from the Department of Justice that also claims bank fraud and what fraudulent is and everything. Everything I am saying, Your Honor, if any person, Senator Kevin Abard or Mr. Gill, said something to me, I corrected them instantly. I corrected them. I never once went outside of my boundaries and said to them.
At one point during the interview, you agreed that he wasn't an owner on the property.
Right,
and
he
then
wasn't
later,
actually-
and then later you corrected.
He's not in order, and that's
Well,
documented here.
he's on the title.
He's not. He hasn't supposed to have been on the title.
No, he wasn't supposed to.
Right, but he was.
That's the problem you're running into in a lot of these statements, that you're glossing over that distinction and
Well, I've been
arguing.
saying it, and I have been fixing it, and everybody has seen it.
You need to be, regardless of what order I make here, I mean, even if I don't grant the request for temporary restraining order, you're potentially on the hook for defamation damages if you misstate the facts, and they meet the other elements of defamation, and you need to be careful when you're talking about these things. Because you know full well that he was on the title until there was an order from this court last year.
Well, they got all the
Right.
paperwork
No, before-
beforehand, and they didn't
Yeah,
see the title.
let's
They
stay on-
saw, I
let's-
am.
let's stay-
And
No,
you
no,
know
I
what,
want you,
Judge?
hold on, so you understand that at that point in time, in the prior, he was on the title. And my concern here is that you need to be accurate about that.
They received the paperwork, they didn't receive the actual title, they received the paperwork from your judgment and the judgment from Judge Weaver stating that he was supposed to remove his name from the title, and he did. They assumed too, just as much as I did, that his name was removed. Okay, that's when I came in and made the correction. No, unfortunately, that was my fault. His name was on the title. But you know what? When we come back to the whole application thing and everything that they still won't admit to, they should have checked his driver's license. If they had checked his driver's license, they would have saw that he was living at 58 Bow Street in Bow, New Hampshire. This is fraud. Whether anyone wants to admit to it or not, it's fraud. Have they come to me not once and asked me about anything, about removing a loan? No. For 3 years, I've been fighting it with you, I've been fighting it with divorce court, and I've been begging, crying, and pleading with them to remove that equity loan.
And just so the record's clear, this is the first case I've had in which this plaintiff has been a party to the
Right,
case.
but the same party to this, with this house, and the equity loan is James Good, and you do have a party to that. I have sent them several emails, and I put it in there, the pamphlet, a copy of the emails of us going back and forth. They've never once offered me a deal. They've never said anything to me. In the very beginning of this, and I have proof of their original loan that they offered me compared to the one that I had to take afterwards, there was they offered me 2.75% as beginning. It jacked it up to 6.75 when they knew they had me, and I had no choice. I've cried, I've begged, and I've pleaded, and I fought with people for 3 years. Now they're threatening to foreclose on my home because they didn't reference out to me that Mr. Goode stopped paying any of the equity loan. Anything about this is nothing more than me trying to set out to people, this is what can happen to you if you make the mistakes that I make, and laws need to be changed. And Senator Kevin Abard right now is down at that legislative office working as hard as he can to get new laws into place. You yourself told me the other day on the court process with here, I am very limited, my hands are tied, there's nothing I can really do. Well, guess what?
Well, that's
I'm
fine.
trying to change those laws.
I've made suggestions to you
And I filled those out today. So you know what, under the Right to Information and the Right of Information Act of 2005, which replaced the Freedom Act of Information of 2002, that is all I'm doing. I'm just giving everybody out there the right to this information and hopefully to change laws. And to give me a temporary restraining order would be useless because they haven't come to me once with any kind of a deal or a resolution. Within 30 days, I'm filing a counterclaim suit against you and I'm suing you.